What's the lay of the land as far as what's the next most likely Second Amendment case to be going up to the U.S. Supreme Court? What do they look like? And with so many lawsuits flying out there, wouldn't it be nice if somebody just did a video kind of going through, okay, here's where we're at. Well, friends, you're in the right spot. Guys, let's get into it. All right, so there are 5 cases with pending writs for certiorari. That's basically the vehicle that you get into the U.S. Supreme Court with. There are 5 cases with writs to the U.S. Supreme Court. We're going to start with those, then we're going to look at some other ones that are out there. Unless you want this to be a 40-minute video, I don't have time for everything, so I'm just giving you the heads up right now that I had to make some executive decisions on this, but we cover so many of them out there, so here we go. The first one is Beavis versus Naperville and State of Illinois. This is the one coming out of the Northern District of Illinois, and this is gonna be a huge one. This is one that we're basically looking at so-called assault weapon bans as well as so-called large capacity magazine bans. In other words, modern sporting rifles and normal capacity magazines. That's what we're gonna be looking at in this case, and this is probably right now the odds-on favorite case that I have across the entire United States to be deciding these issues. And by the way, I should add, we've done plenty of videos on particularly this case, but also most of these cases, or many of these cases, of me covering today. So be sure to check out the channel. We'll link some of them up in the description box below as well. The next topic we're going to be talking about are bump stocks. Remember those? Well, there's some really important issues going to be going on there, and we have a split circuit decision. In other words, we have 2 different circuits. That's 2 different portions of the country. The federal courts of appeals have basically contradicted each other. We're talking about the case of Garland v. Cargill coming out of the 5th Circuit, particularly, that basically struck down the bump stock ban in that particular state. And I think that that's the most likely case to be taken up to the U.S. Supreme Court. So keep an eye on that one. And again, we've done videos on that one as well. And I will also note that prior to the split decision, that actually the U.S. Supreme Court has denied certiorari on 2 different occasions, both in October of 2022. So coming out of the 10th and the 6th Circuit, I believe, respectively. I think the fact that we now have a split circuit decision, that's a common way that a case gets kicked up to SCOTUS, and here we go. Another one is a case that we actually just recently have covered, but we also covered originally, and that's U.S. versus Rahimi. We're dealing with who are the people in the Second Amendment of the rights of the people to keep and bear arms shall not be infringed. Who's the people? In this particular case, we might be specifically talking about the domestic violence restraining order issues, but in reality, again, this case will likely give a lot of guidance as to who the people may exactly be. The 4th case that we're going to be talking about is NRA v. Vullo. I apologize if I mispronounced that name, VULLO, which is actually a First Amendment claim against New York's Department of Financial Services, or DFS. The court has requested a response in Vullo with response deadline of May 24th, but a motion has been filed to extend that deadline to June 23rd. We've not covered this on our channel, nor the one that follows, so if you want us to follow those cases, let me know in the comment box below. The 5th case is Seekins versus U.S., which is a case involving flare gun shells. So beyond the U.S. Supreme Court, what are the cases that are basically on the way? Well, the big one, of course, to me, you got to go pistol braces. And if we're talking pistol braces, there's so many to choose from, but I'm going to go Mock v. Garland. Now it's starting to feel like a fantasy football draft. This one's coming out, of course, out of, again, the 5th Circuit Court of Appeals, and this just frankly has the U.S. Supreme Court written all over it for all the issues that are involved here, which we've covered so many times before. But again, Mock v. Garland from the 5th Circuit Court of Appeals, that's probably going to be our pistol brace case. It's going to be going up. Look for that to go up probably in the next 18 months or so as far as when we should be getting a decision back if all goes well. Beyond that, we're talking about ATF SBR cases. Now we're talking about the Firearms Regulatory Accountability Coalition, otherwise called FRAC, as well as Franklin Armory versus the ATF, or the BATFE. This case involves January 2023 in federal district court in the Western District Court of North Dakota. This case is simply kind of a technical mess caused in no small part by the fact that the National Firearms Act and the Gun Control Act actually have somewhat different definitions of what is a shotgun. The NFA, in relevant part, defines the term shotgun as, quote, a weapon designed or redesigned and made or remade to use the energy of an explosive in a fixed shotgun shell to fire through a smooth bore. The Gun Control Act, in contrast, says, and the relevant part reads, quote, a shotgun is a weapon designed or redesigned and made or remade to use the energy of an explosive to fire through a smooth bore. Thick shotgun shell versus smooth bore, those are some of the issues. Again, not a case that I've covered. If you want to see me cover this, let me know in the comment field below. And I'd be I'd love to dig into it if people are really interested. So basically the issue here is the plaintiffs are alleging that the ATF has misclassified their particular firearms as being NFA devices and all that kind of stuff. The ATF naturally has already changed their position and issued basically a walk-back letter that's changed some things, and, away we go. Of course, remember force reset triggers, rare breed, wide open triggers, all that kind of stuff, right? That's US versus Rare Breed Triggers LLC. That's still out there. What about the nonviolent felon bar, where even nonviolent felons are barred from their Second Amendment rights? Well, now we're talking about Range versus Attorney General of the United States, also a June 2023 case. That's where an 11-4 ruling from the Third Circuit Court of Appeals based out of Philadelphia said, quote, "In sum, we reject the government's contention that only law-abiding responsible citizens are counted among the people protected by the Second Amendment," end quote. Basically what he did is he lied on a food stamp application back in the 1990s, and he, as a result, grifted $2,458 in food stamp assistance. Now, he actually lost initially in the Third Circuit, petition for what's called an en banc. In other words, hey, instead of only a couple judges to hear this case, because maybe I got a bad draw of judges who I think maybe were not favorable to me, I'm going to petition for an en banc. All the judges met. They review cases like this where somebody petitions. They voted to hear it, reversed it. So we actually had 2 Third Circuit Court of Appeals decisions out of this. Another one is the 18 to 20-year-old handgun purchase ban. This one we did do a video on. This is Frazier versus BATF, where a district court out of Virginia says that basically, the Second Amendment, again, we're looking at who the people are, and the court said, the people, that includes 18, 19-year-olds, and 20-year-olds, because, of course, right now, federal law prohibits FFLs to transfer handguns to adults under the age of 21. So when we're talking about who the people are when it comes to handgun purchases, the words "shall not be infringed" rang loud and clear. Likewise, waiting periods for 18 to 20-year-olds were coming out of McRory v. Garland. This one deals with the bipartisan Safer Communities Act, which was signed into law in 2022 that compels a possible and often de facto 10-day waiting period for NICS check when it comes into juvenile records for the individuals under the age of 21. What's going on here in English? Well, NICS, that's the National Instant Criminal Background Check System, is not always so instant. If you didn't know that, the FBI reported that approximately 87.98% of their checks were actually instant in 2021. So 87% of the time, good, instant. However, 87% sounds good until we start to consider the fact that 87% of 39 million background checks means that it was not so instant for 12%, or about 4.7 million people who were delayed, as pointed out by the, of course, Gun Owners of America, who are leading the charge on this lawsuit, the GOA. 90% of those delays, they calculate, turn out to be false positives. So to remind you about this, if the NICS comes back and tells the dealer, look, proceed, they can proceed. If they deny, then they cannot transfer. But if they hear nothing, it's up to the dealers to whether or not they want to transfer after 3 days have lapsed. Okay, that's the current system. Works okay, but not the best. So the Bipartisan Safer Communities Act said, look, this system works so well, let's just add about 1,000 pounds of weight to it, right? Because in essence, what they did. So now under the Bipartisan Safer Communities Act, when we're talking about transferring firearms to adults under the age of 21, NICS must not only do their normal clearance, which is an 87% deal, but now they also have to get the clearance in order to authorize the transfer from 3 new groups: the State Repository for Juvenile Justice Records, a state repository for mental health records, as well as the chief law enforcement officer for the particular area. Now, under the challenged provisions here in the lawsuit, the dealer is basically left with the decision about whether or not to exercise their discretion to transfer the firearm after 3 business days if no further cause is found, or after 10 days if further cause is found and it's not resolved by NICS. If the dealer declines to transfer the firearm, even though they could be permitted to because there's nothing stopping them, then okay, the young adult purchaser basically got delayed indefinitely, and i.e. they basically got denied, sort of. They can always go ahead and try to repurchase and start the 4473 again, but you see the problem there. If everything worked perfectly every time, then this would result in an instant clear. But the FBI has already made clear that as of November 14th, 2022, in a statement, every firearm purchaser under the age of 21 will automatically be delayed receiving a response from the NICS system of up to 10 business days. Right. So it's created a de facto waiting period. Is this all constitutional? That's that lawsuit. We also have the frame receiver rule, which we've covered on this channel before. That's Vanderstock v. Garland. That's, of course, being led by the FPC, as, by the way, was Mock v. Garland, the pistol brace charge, although GOA and other groups are involved as well in other cases. We have felony indictments. That's whether or not a case pending can work. Recently, of course, we did a video about US v. Holden coming out of the 7th Circuit Court of Appeals, but that's a little bit of a different issue. We also have USA versus Quiroz, Q-U-I-R-O-Z, which is out of the U.S. District Court in Texas, challenging the 922N, those prohibited by a felony indictment. They've not been convicted. They've basically just been charged. Coming down the home stretch. And before we do so, don't forget to show your support for the Second Amendment in this channel. Click like. Be sure to stick around for a quote of the day at the end. Subscribe to make sure you don't miss any future of our content. If you want to support the channel beyond that, pressing like is the best thing you can do. But of course, if you want to take it to the next level, also check out our membership options. Be sure to comment below what you think is going to be happening on these. What, if any of these cases are going to go places, and what do you think is going to happen with them? We also have a case, and I apologize for this butchered pronunciation as well, Yukutaki versus Shikata, and I, again, apologize for any mispronunciation. This is a lawsuit coming out of Hawaii's which banned the carry of batons. The state's actually already agreed to be enjoined. In other words, they will not enforce the law. And it's actually paying the plaintiffs $50,000 for their legal fees. That happened on May 23rd. We also have Paxton v. Richardson, which is challenging the National Firearms Act in Texas for making a suppressor that they will not be putting in interstate commerce. And we also have DeWild versus United States Attorney General. This is just looking at NFA transfers in general. And last but not least, we have another one, Santucci versus Honolulu. This is a 2022 lawsuit filed against the city/county of Honolulu, in which the city was requiring any applicant for firearm registration to provide written certification from a medical doctor. Right. So that's being challenged as well. So as I mentioned before, there's about another at least dozen cases that I came across, but I don't want to push this to an 18-minute video. So if you want to see kind of a part 2, let me know in the comment field below. But these are kind of some of the heavy hitters that are out there. Now for your quote of the day. The price good men pay for indifference to public affairs is to be ruled by evil men. That's from Plato. I will see you in the next one, guys. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.